Okay, well, let's start. Let's go. So good morning, everyone. Do you hear me well enough, or shall I use the mic? Is it okay like that? Thank you. So welcome to this new session of RAN's Law TTIP seminars. Thank you for being there. And above all, thank you to our colleagues who made a long trip to join us. Some came from Ukraine, Norway, very far. Thank you also to colleagues who had to defeat viruses to be here with us today. And I really want to let you know, all know, that we are very, very happy to have you here today for this seminar. So we would like, with Isabel, who is with me in this welcome speech, we would like to thank also Nicolas, Cyril and Catherine Kemener, who actively contributed to the organization of this event. As some of you may know, Law TTIP seminars are one of the various activities that we organize within the Jean Monnet Network Law TTIP, that we share with the University of Bologna and King's College London. And we've been conducting activities for the past 2 years, and we'll still have activities this year in Rennes, London and Bologna, among which we will have a joint conference in London in March, just before the 29th. And we also organize in June in Rennes a young researcher workshop on internal and external challenges of new generation of FTAs of the EU. RAN's Law TTIP seminar series is more specifically dedicated to the impacts of EU FTAs on the external action of the EU in a more broader sense. We had the first seminar last year focused on CETA, which addressed issues such as provisional application, regulatory cooperation, etc., in a comparative law approach. And for each seminar, we try to have an external view, that is to say, to have also during our discussion a non-EU perspective on what the EU does. And so we had that last year with a Canadian view, and this year we'll have a Ukrainian view, a South African point of view of what the EU does as a trade and international actor. So today we'll hold 2 sessions of our seminar in one day. Considering the respective topics that we chose, we thought that it could be consistent to have the 2 panels discussing with each other and to unite the 2 sessions under one common title, DCFTAs and EU's Neighbourhood. The United Kingdom being, at the time of speaking, encompassed in the EU part of the expression of EU's neighbourhood, but could be moving on to the neighbourhood part of the EU's neighbourhood expression. Our morning session will focus on EU DCFTAs and the neighbourhood policy, or maybe I should say within the framework of the European neighbourhood policy. And this afternoon we'll have a roundtable on Brexit and EU FTAs. Of course, everybody should feel free to comment, ask questions to our speakers, and we'll try to save the maximum time for discussions and debates. So if everyone's okay with that program, we'll just start with the first session, and I'll maybe should say just a few words before I before I introduce you, Peter. About the first session. So the first session is dedicated to the new generation of FTAs of the EU and the neighbourhood policy. And if I introduce really briefly why we chose this topic, well, I think most of you are familiar with the basics of the European neighbourhood policy, so I'll go real quick on that. But we have neighbours identified to be eligible to the European neighbourhood policy in the east and the south of Europe. And within this policy, we have common principles, common methods, among which guiding principles for the relation: bilateralism, differentiation, conditionality, ownership. And the idea is that each bilateral relation with the neighbors will be deepened and will progress according to the partner's merits and progress. And the method is very much based on, was very much based on a method used for enlargement policy also. And it builds on pre-existing bilateral agreements, associations agreements establishing free trade, the Euro-Mediterranean association agreements in the south, and it used to be built on partnership and cooperation agreements in the east, and those agreements have been, well, some of them have been upgraded to association agreements and have been replaced by associations agreements, including DCFTA, that is deep and comprehensive free trade agreements. So, why did we think it would be interesting to have a focus on neighbors? Well, pretty much because if the general trend is to negotiate FTAs with many partners, Canada, Australia, New Zealand, Japan, Korea, Mexico, etc., we tend to believe that the implications of such FTAs might be different than the implications of FTAs that we conclude with neighboring countries. At the same time, the increasing number of those FTAs with further countries might also impact trade flows and, more generally, the so-called privileged status that the neighbors are being offered. So this brings us to another interesting question, which is, are DCFTAs in EU's neighborhood specific in some ways when compared to other FTAs? Should the answer be positive? In which way are they specific? Are there any differences between DCFTAs with eastern neighbors and the one being negotiating with some of the southern neighbors? Those are some of the questions that will be addressed this morning. And we'll hear successively 4 speakers. So, Professor Catherine Barrault, Professor Peter van Elsoewegge, Professor Roman Petrov, and Dr. Nicolas Pigeon. The first 2 speakers will focus more on eastern neighbors, and our second 2 speakers, that is Catherine Barrault and Nicolas Pigeon, will focus more on southern neighbors, but I'm pretty sure that each presentation will echo with each other. So I first leave the floor to Peter van Elsoewegge from University of Ghent. And before he starts, I would like to say that remind that University of Rennes and University of Ghent have had a long tradition of cooperation, especially when it comes to EU law studies, and even more specifically in the field of external action. So it's an even greater pleasure to have him here. And I was told that it was his first time in Rennes, so I hope it won't be the last time in Rennes. And Professor Peter van Elsoewegge will question the possibility of DCFTAs with Eastern neighbors to become a model for other bilateral relations with the EU. So he's thinking as a model for the UK relation with the EU, for the Mediterranean countries, for other type. Well, we'll just have to let him tell us about it. Thank you, Peter. You have the floor.
Thank you very much for the kind introduction, and it's definitely a pleasure to be in Rennes. I heard my colleagues talking about Rennes so many times, and also hosted some colleagues from Rennes in Ghent. So it's my pleasure to be here personally for the first time to discuss issues of EU's external relations law. I will address the question to what extent the relatively recent establishment of deep and comprehensive free trade areas with the EU's eastern neighbors in the neighborhoods, and as part of association agreements with Ukraine, Moldova, and Georgia, to what extent might this be seen as a kind of model for future relations with other countries? Of course, there are the negotiations with some Mediterranean countries. We'll hear about this later on. And frequently also in all kinds of discussions, Ukraine is referred to, or the DCFTA with Ukraine is sometimes referred to as a potential model for the post-Brexit relationship with the UK. So this will be the background of my presentation. In order to do so, I want to start actually with a quote from former European Commissioner for Trade, Karel de Gucht, when he basically introduced this notion, this concept of deep and comprehensive free trade, when this was introduced in relation to the negotiations with Ukraine. It was said that the EU was making a kind of unprecedented offer of deep integration into the internal market. We might discuss, I think, European economic areas, perhaps even more a form of more deeper integration. But nevertheless, with respect to Ukraine, it was quite a new instrument, and as was you can read, it was also the introduction of another abbreviation in the EU trade jargon, called Deep and Comprehensive Free Trade Area. So what I'll do basically is three things. First, I'll say a few words, elaborate a little bit more upon the background of this concept of DCFTA, how this entered into the EU's discourse in relation to the neighboring countries, in relation to the neighboring countries, the eastern neighbors in particular. Then we'll focus on some specific key features, key characteristics of the DCFTA concept with respect to the eastern neighbors, and then come to this potential discussion, which is more an issue for further debate about the potential implications for the other neighbors. So starting with the concept of DCFTA and how it was introduced in the EU's neighborhood relations, it is interesting to look back at the gradual development of the European neighborhood policy, and in particular the trade dimension of the European neighborhood policy, where at the very beginning, in the first documents, the first reflection papers about the EMP, a reference was made by, at that time, Commission President Romano Prodi, that the European Union should offer the neighboring countries a stake in the EU internal market. And obviously there were some parallels made with the model of the European Economic Area. Now, it was rather quickly it became clear that this was not a very realistic offer, because also the EU member states were not really, and also the third countries probably were not ready for this type of very deep integration covering the four economic freedoms. Particularly free movement of persons was something that was quickly removed from the agenda, and we could see gradual development from the offer of a stake in the entire internal market to a more specific offer, and the more specific offer would focus particularly on integration in relation to goods and services in the first place. And here, I think we can see kind of spillover, a kind of interconnection between developments in the area of the EU's trade policy on the one hand, and then kind of implications of this development in EU's trade policy for the European neighborhood policy. A key development was the introduction of the EU's Global Europe strategy in 2006, where after the failure to proceed on a more multilateral level in the framework of the WTO, the European Union's trade policy was focusing more on the conclusion of a new generation of comprehensive bilateral free trade agreements. So it was mentioned that the Union would develop new initiative to have a new generation of comprehensive, ambitious free trade agreements where non-tariff barriers to trade would be tackled. And there, the EU's trade policy was very clear that the focus should be on the most important trade partners, so the countries where there was a lot to be gained from also European Union perspective. So reference was made to countries like Korea, Canada, Singapore, and so on. So there was no reference to the neighboring countries. But we can see that this idea of a kind of new generation of comprehensive trade agreements tackling non-tariff barriers to trade was introduced into the European neighborhood policy in actually the same period, where the EMP documents would no longer refer to the four economic freedoms, but would focus on this concept of comprehensive and deep new generation of trade agreements. So I think that if we look at the evolution of the European neighborhood policy, we can see a kind of spillover effect or kind of links with other developments in other policy areas. Of course, particularly at the very beginning, it was inspired by the methodology of the EU's enlargement policy. And here, I think, with respect to the DCFTA and the trade dimension, there was this link with this EU Global Europe strategy, where the idea of comprehensive free trade, new generation of comprehensive free trade agreements or areas then was moved into the discourse of the EMP, where the logic, the rationale was not necessarily an economic logic, but mostly a political logic. So the idea to have deep and comprehensive free trade areas was not necessarily relevant from an economic point of view, because the countries only are responsible for a very limited amount of the EU's trade volume, but they're of course politically very relevant. So this, I don't know whether it's very visible, but it's a kind of visualizes the background of the idea, with the ultimate objective is to create a safe and prosperous neighboring countries, so that was also enhance the security of the European Union itself. And the deep and comprehensive free trade area is actually one of the building blocks of this broader concept, of this broader objective. So the idea is that when you have deep and comprehensive free trade areas, you will have attract more foreign direct investments, you will have an increase of income, more prosperity, more stability, so that contributes to the stability of the entire region and ultimately is also in the EU's interest. That explains why DCFTAs with the Eastern neighbors are embedded into a broader framework and a broader logic. They're also, from a legal point of view, there are no separate agreements. They're an integral part of the new generation of association agreements, precisely because of this logic. It coincides with other parts of the association, also including the political dimension. Now, if we then look into the specific features, characteristics of the DCFTAs with the Eastern neighbors, I think there are two elements to be distinguished. It's on the one hand the comprehensive aspect, on the other hand the deep aspect. If we look first at the comprehensive character of the DCFTAs with the Eastern neighbors, so what kind of aspects are covered in the agreements, this is perhaps not the most innovative or specific element if you compare it to other trade agreements, because the scope is quite comparable to other trade agreements. If you compare it to other recently concluded trade agreements, you can see quite some parallels in terms of the scope. But the difference is much more visible when we look at the deep character of the DCFTAs, and that makes the relationship with the Eastern neighbors rather specific. It's the focus on legal on legal approximation, where you have not a single reference, and Roman will probably say more about this, but you have an entire network of different types of legislative approximation clauses, where the idea is that the Eastern neighboring countries will adopt their legislation in line with the EU acquis, so that we have a kind of common legal space. What is very specific about the DCFTAs with the Eastern neighbors is the conditionality approach, and that's the link with the enlargement methodology, which still plays a role, or which can still be found if you analyze the association agreements, if you analyze also the methods of the DCFTA, because further market access is offered, but not on the moment that the agreement enters into force, but only at the later stage when the Association Council managed to check whether actually this process of legislative approximation has turned out to be successful. So it's quite far-reaching. It influences the kind of national sovereign choices of the countries themselves, but because they commit themselves to change their domestic legislation in a number of areas. So it's far-reaching, challenging, because you have different types of obligations for different sectors, is quite costly in terms of the investments of changing legislation. The short-term benefits will be in the more longer term. So this is what I'm referring here to the work of Guillaume van der Loo, a colleague from Ghent, who did his PhD thesis on the EU-Ukraine Association Agreement and the deep and comprehensive free trade area, should be, not association, and analyzed this in all details and referred also to this mechanism of market access conditionality, where the agreements themselves include a number of obligations. You have references to annexes where you can find the EU acquis, for instance, in relation to public procurement, and then you have a period of implementation and monitoring, and only then the Association Council will decide whether or not this has been a successful process of legal approximation, and only then, after this decision, Ukrainian companies, for instance, in the example of public procurement, will be granted equal treatment in comparison to EU companies. So that is in my view, the specific feature of the DCFTAs with the Eastern neighbors. So after having sketched this background, then perhaps the question which is open for discussion, to what extent can this be regarded as a model for other countries? I think it's rather difficult to I mean, at least to see it as a concrete model that can be more or less copy pasted to other countries, particularly because of the background I explained. I mean, it has been developed with respect to those countries with a particular logic in mind, with a particular challenge of those countries in mind. And if you want to copy this to other neighbors, you will face different challenges. If you look at the southern neighbors, well, there are significant differences. On the first place, those countries, by definition, do not qualify for potential EU membership, whereas the Eastern neighbors at least have the aspiration to become members or potential candidate countries at least one day. So that was the background also of the initiative, that you have a far-reaching process of legal approximation that will help them on realizing their ambitions of integration with the EU. The situation for the southern neighbors is different there. I mean, they do not have this type of aspiration, so it's much more difficult to implement it with those countries. Also, they already have association agreements. They already have more traditional free trade areas with some protocols and some further liberalization in certain areas. So what can be offered is also different in comparison to what had been offered to the Eastern neighbors. So that makes it, in my view, rather difficult to simply think about a kind of model or copy-paste exercise, but it's something to be discussed. We'll hear more about this by the other presentations. Then the next point is the potential model for Brexit. Well, for a number of reasons, I don't think so. Maybe in terms of the comprehensive aspect and the issues which are covered, it sounds very attractive because there is nothing really about persons, and movement of persons might perhaps be covered separately with UK. So in terms of the comprehensive aspect in terms of goods and services, there might be some links, but not necessarily when it comes to the deep aspect, because the DCFTAs with the Eastern neighbors are very much based on this conditionality approach, which I don't think will be a model for relations with the UK, because you start from a different background, you have different challenges. With the Eastern neighbors, it's a process of integration. With the UK, it's actually a process of disintegration. I mean, it's not about gradually changing your domestic legislation to adopt the acquis. They already are members for the time being, so it's a different type of challenge, it's a different type of process, and one should think also about the UK red lines and the agreements with the Eastern neighbors. There is, for instance, the not only the conditionality approach, but also the role of the Court of Justice for if there are disputes regarding the interpretation of the EU legislation. So this all makes it rather difficult to say that this is a kind of perfect model for a post-Brexit relationship. But of course, this is just some ideas for further discussion. So I would like to finish here in order to have sufficient time for questions and debate.
Thank you, Peter. We have now a first view of why DCFTAs are deep and comprehensive, and why they're specific, and the difficulties of having them as a model for other relations. Now I would like to introduce Professor Roman Petrov. Oh, we'll have just technical break. So Professor Roman Petrov, who's from National University of Kiev, if I'm not. Yeah, well, I cannot say that. I cannot pronounce that correctly, so I'm sorry about that. Well, I must say I'm very pleased that he accepted our invitation, for I've read many papers he wrote, and for my own researches, and we share a common interest, passion, obsession, I don't know how you want to call that, for normative influence, approximation of laws. So it's sincerely a real pleasure to have you here today, and for your first time in Rennes also, I believe. So approximation of law will be one of the issues addressed by Professor Roman Petrov, who will focus on the impact of legislative approximation clauses lying within EU's DCFTAs with eastern neighbors, and the impact on their internal legal system. So, Professor Petrov.
Thank you. Thank you. Yeah, thank you very much. I have about 20 minutes, yes? Just, yeah, yes, thank you. It's a great pleasure to be here. It was one of my dreams to come to this place. A word about Rennes is being spread by your alumni around the world, and I'm really pleased. Thank you for inviting me. Well, the topic what I'm going to talk about right now is, of course, very wide, and it's very difficult to embrace it. It has been a topic of my almost life research, and with such a significant impact on life of my country, my family, my friends, and so on. It's true, indeed. On this picture, you can see some sites of my university. It's my university it's called after Metropolitan Petro Mogila, who founded it in 17th century. Well, the structure of my talk, I'm going to talk about the background, briefly about historic background of the EU, Ukraine, Moldova, and Georgia relations, related to the association agreements, of course, then objectives and structure of the agreements, anatomy of approximation clauses in these agreements, and impact and challenges of these agreements on legal systems, orders of Ukraine, Moldova, and Georgia. And it's quite reasonable why these three countries, because these are only three countries which signed and entered into 4 association agreements with the EU among all Eastern Partnership countries. Looking briefly at the historical span and timeline of relations between the EU and Ukraine, Moldova, and Georgia, and of course I mainly focus on Ukraine. It's very reasonable to start with partnership and association agreement. Partnership and cooperation agreements, which it was a package deal offered by at that time by the European communities for all post-Soviet republics. It's still valid now, it's still in place, so it's been enhanced like mobile phones plus. There is a PCA plus, and there is PCA 2 plus, which is in case which works for Kazakhstan and Armenia. So it's very interesting how this project, this package deal, is being further developed and enhanced. There are no agreements yet enforced with regard to Belarus. It has not been signed yet due to renowned political reasons. And if I'm not mistaken, Turkmenistan. Peter, yes? Am I right? Tajikistan, yes, but not Turkmenistan, but it's also explained by very specific, peculiar regimes there. There is a very tough, difficult to describe, but just for you to understand, the leader of the country, eternal leader, has changed the calendar, has written the book which was sent to the space, and he changed calendar with the name of his mother, his family, so it just explains you the situation. in that country. So it's the idea of the PCA, not really with its essential elements with the emphasis on democracy and common values doesn't really fit completely what's going on. But nevertheless, it's a rich oil country and gas country. So there's something, what I already read from the external service press conferences, they're thinking about sort of reviving some plus, offering something special, because it cannot be missed anymore in terms of energy supply for the EU. So the PCA deal is still there. With regard to Russia, it's still a valid agreement, so it's being prolonged every year, if I'm not mistaken, because the agreements were signed, entered into force in 1997 for Russia for 10 years, for Ukraine in 98, so it's been ad hoc agreement now since all political and contractual relations. The negotiations to conclude a new agreement have been frozen due to political standstill between two countries. For Ukraine, it was a very important agreement, of course, but it was transitional. And by year 2000 already, these package agreements were outdated due to the reasons that the major idea of these agreements was to push post-Soviet countries towards market economy and democratic reforms. And one of the objectives of these reforms was the membership in the WTO. And by year 2005, and later for Russia 2012, mainly these two big participants of this package deal already gained this membership. So basically these agreements for other reasons too got outdated. And it explains why Ukraine, especially with its traditionally pro-European foreign policy, was insisting on something else, on something special, and which could lead to the membership. And it was considered that association agreement, especially in the aftermath of the big bank enlargement, 2005, it was considered as a proper deal for Ukraine. Nevertheless, the EU replied with ad hoc policies. First, European Neighbourhood policy, you're quite familiar with it, with details of this policy. Then Eastern Partnership, with what was designed specifically for Ukraine and other post-Soviet countries, namely Belarus, by the way, Ukraine, Moldova, Georgia, Azerbaijan, and Armenia. Russia was invited on board in both cases, but it refused, despite being a geographical neighbor to the EU. And in its opinion, it was a project to hijack the geopolitical sphere of influence of Russia around the post-Soviet area. However, the real breakthrough, and by the way, there was a big ongoing expert and academic debate whether the association deal was ever possible for Ukraine. There was a big discussion. Frankly speaking, in my opinion, I could never believe at that time that it is possible, because I thought, no, it's too political notion to be offered to Ukraine and other post-Soviet countries. And I thought that the only deal like PCA++ would work for many other reasons. However, by the way, it must be mentioned, especially here, I don't know if President Sarkozy was ever popular here. I'm not yet familiar with the political kaleidoscope. But if I'm not mistaken, it was actually him who pushed this idea forward, saying when France was at helm of the EU presidency, that why not? Why not we accept and under certain conditions have start negotiations on association deal with the post-Soviet countries. And it was somehow accepted, and negotiations started in 2008, if I'm not mistaken. There were 26 rounds. Some people in this room took very active part in this process, consulted the both sides, and it was a very interesting process. And by year 2012, the text was ready for all 4 countries at that time. Ukraine, which was the leader of the negotiation process, Moldova, Georgia, and Armenia. And I think by year 2012, the text, especially the Ukrainian association agreement, was initialized. It was ready to be signed. And I think, it's my personal opinion, it was a big historical mistake and blunder, failure on behalf of the EU not to sign it in by spring or autumn 2012. When the text of the agreement was not yet public, when the Russian government was not yet deep in details of this agreement, and the Ukrainian side, by the way, was ready to sign it, headed by Yanukovych and his government. It was always officially proclaiming that we are in favor. But due to the political situation in Ukraine at that time, Julia Tymoshenko, whom you might know, and who might be in a couple of months be elected as the new president of Ukraine, who knows. She was imprisoned by Yanukovych for signing a gas contract with Putin. She was in prison, and therefore the European Parliament and other European institutions decided to trigger the conditionality button and to stop. And it was officially proclaimed that no signature unless you release Tymoshenko. There was a Cox-Kwasniewski Commission delegation to the Ukrainian Parliament with sort of mandate to release Tymoshenko. Yanukovych never did it. Instead, by summer 2013, the Russian side decided that the association deal with Ukraine in particular was against core policy, foreign policy and strategy of Russia. It was a violation of its geopolitical dominance in the area. And by September 2013, the trade war already has started. As you know, first bell was run when in September 2013, Armenian president officially refused to announce the change of the foreign policy. And it was actually first, not Ukraine, but Armenia, first country to refuse the signature of the association deal. And instead joining the future Eurasian Economic Area project. And in November 2013, Ukrainian president, and which led to well-known protests called Dignity Revolution. Dignity because it's actually Ukrainian people considered it's a violation of their dignity when foreign policy of country is being changed in a 1 hour, drastically in one turn without any consulting any kind of representative assembly, parliament opinion of Ukrainians. So it was a reason, it's why it's called Dignity. Then all these catastrophic events which led to victims and annexation of Crimea and the war in the east of Ukraine. So it's a very big historical span, and which explains a situation. And again, the association agreement with Ukraine was rather unfortunate in my opinion, because despite that it was signed in the summer 2014, together with Georgian and Moldovan association agreements, it entered into force only 3 years later due to very long ratification process and the renowned Dutch no referendum, which was related, which could be explained by many reasons, which are not directly linked to the content of the agreement, by the way. But it's another story. So by basically only 1.5 years ago, in September 2017, the Ukrainian association agreement entered into force and became part of our legal system. Well, yes, and so what objectives of this agreement? As already Peter well described, it's one of the most ambitious deals ever signed by the European Union. It's a huge document. It depends on a script, of course, but it's about 2,000 pages with many annexes and protocols which list the vast scope of the EU acquis, relevant EU acquis to be adopted by the Ukrainian legal system. The legal base is classical, but with some innovations at that time. Article 217 Association Agreement plus Article 31 and 37 of the Treaty on the European Union, CFSP. At that time it was rather new. And, but it must be also emphasized that agreement, despite being association agreement, doesn't mention the perspective of the EU membership for Ukraine as well as for Georgia and Moldova. However, it says the door is always open, and this agreement in its preamble support and confirm European identity of these countries, which in my opinion could lead to Article 49 saying that only European countries may apply for the membership. So theoretically it's it's sort of a compromise, and our political elites say that, well, we didn't manage to negotiate the European membership clause, but theoretically we can always apply for the membership since we are European countries as considered in these agreements, with exception, by the way, to Georgia, because in the preamble of the Georgian agreement, Georgia is described not as a European but East European country. And it's always a very interesting topic of debate with my Georgian colleagues, whether teasing them whether they could apply or not, being East European, since we are European. It's rather interesting, but a very interesting language, which could mean have some relevance. Then it's a deep and comprehensive free trade area, and Peter has already described. By the way, there was no free visa regime enshrined in the agreement, despite expectations. It was a completely different process. Now already it's a history, and all three countries, Georgia, Moldova, and Ukraine, enjoy visa-free regime, and people already got used to it. New common institutional framework, which is very important, Association Council, Parliamentary Committee and committees, and Association Council can issue binding decisions, which is very, very important for our legal system. There haven't been any yet binding decisions, unfortunately, which could impacted our legal systems, but already there are some new disputes which are arising now. Which also could be considered within the dispute settlement mechanism. Of course, further convergence between Ukraine and the EU on foreign policy, regulatory approximation, and cooperation on vast range of issues. So basically, shortly speaking, the agreements, they are cross-pillar in former sense, pre-Lisbon. Their framework, they cover almost all the issues of the EU competence, including now, it's a big debate on how Ukraine and Moldova and Georgia potentially could also take part in the common defense policy, especially taking into consideration these new initiatives taken by the EU, and it's already been discussed in these countries. But it's not yet directly, it isn't directly covered by the agreements. It's something which has to be considered. Innovative character of these agreements, I referred to this classification developed by Peter at a certain point of time, and he emphasized three major features of these agreements. Complexity, it means advanced mechanism, secure, uniform interpretation, effective implementation. Comprehensiveness, it means arch framework type agreement, including all EU policies. And conditionality, very strong conditionality. Basically, conditionality works in a way how it worked with regard to the candidate countries, very similar to the pre-accession strategy, regular annual monitoring reports on the progress of reforms in these countries, which are conditional on further rapprochement and integration. And it plays a very important role for our domestic internal reforms. Coming closer to the approximation clauses. Before these agreements, we EU external relations scholars, we used to discuss and talk about sort of traditional approximation clause, usually one clause in the agreement, which was inherent to Europe agreements with the Central and Eastern European countries, stabilization association agreements with Western Balkan countries, not very much to the EA, but still, usually, traditionally, EU external agreements used to have one clause which was sort of general and which described the character of approximation, legislative approximation. The only difference was a word either, for example, partnership and cooperation agreements used to employ endeavor to approximate, endeavor. And we all asked our English-speaking colleagues what actually it means, endeavor, how far and how binding. Whereas Europe agreements used a jargon saying shall approximate or must approximate. So there was certain difference in wording which indicated some kind of bindness of these approximation clauses. However, it was, of course, very much political. It was very much supported by the accession strategy, status of the candidate country, and so on. The Ukraine, Georgia, and Moldova agreements, they were probably the first which had a very complicated, intricate system of approximation clauses, which basically converge everything what the EU has developed in its practice. So I tried to put certain hierarchy and indicate for you. For example, if we talk about approximation clauses in the EU-Ukraine Association Agreement, we can see one so-called general gradual approximation clause, Article 474, and I quote, Ukraine will carry out gradual approximation of its legislation to EU law. Of course, with references to the annexes, to the EU acquis in the annexes. Then soft approximation clauses in different chapters will gradually approximate, shall be implemented. Then sort of hard approximation clauses in a chapter related to the DCFTA. Ukraine must incorporate relevant EU acquis in line with specified timetables, and these timetables are usually contained in the annexes. So every single chapter of the title had its own approximation clause and own timetable and all scope of the acquis contained in the annexes. And what's very important, interesting, and a so-called sort of dynamic approximation clause, which could resemble to a certain degree a dynamic approximation clause in the EA agreement. Of course, not so much, it's not homogeneity, but I quote, Ukraine shall ensure that its existing laws and future legislation will be gradually made compatible with the EU acquis, with the possibility of the revision and update of this acquis in line with new developments. Again, it's not homogeneity, but it also relates to certain fields. For example, like competition law, procurement, but it's still there. So basically, in my opinion, it was a very interesting kaleidoscope, a mixture of everything what the EU has practiced upon and tried to introduce in its practice. If we look at the Moldova and Georgia association agreements, they had a bit different. Probably the Ukrainian agreement was the most advanced in this sense, but I would like to pay your attention to the dynamic approximation clause in these agreements, and it says the Association Council will periodically revise and update those annexes, including to take into account the evolution of EU law as defined in this agreement. Yes, so it shows that basically the Association Council has the competence to revise. Of course, there is a debate how far it could go, because still the Association Agreement is an international agreement, and constitutionally it could create problems, certain disputes for legal systems of Ukraine, Moldova and Georgia. But it's another story. It hasn't been in place yet. Dispute, another novelty and very interesting provision, which was firstly for the first time introduced in the association, in that generation of the association agreement, is a dispute settlement mechanism. There is a mechanism which envisages, which resembles WTO mechanism, but in order to solve the disputes between the countries. But for the very first time, there was a provision which actually allowed it sort of, I would say, kind of preliminary ruling, if we could say, when this particular dispute settlement body, in case of considering issues related to the approximation, could directly refer to the European Court of Justice. It says, where a dispute arises, a question of interpretation of EU law. In such cases, deadlines applying to the rulings of the arbitration panel shall be suspended until the Court of Justice of the European Union has given its ruling. The ruling of the Court of Justice shall be binding on the arbitration panel. So it's binding ruling of the ECJ is envisaged, which is very interesting. It hasn't happened yet, but it's there. This provision is sleeping there. And finally, if I'm still within the time frame, impact of these agreements on the Ukrainian legal order and legal orders of other countries. First of all, just very briefly, it could be described for endless time, of course. It's a very interesting topic to talk upon, but something which was certain emphasis. First of all, the association agreements so far, for quite yet not really mature and evolving legal systems, post-Soviet legal systems of these countries, Moldova, Ukraine, Georgia, these agreements are most ambitious and the most far-reaching. They imply considerable changes and integration and impact on legal system of these countries. For many reasons, including the reasons what I have already described, this very profound approximation clauses, references to international court, which is the European Court of Justice, dispute settlement, and so on, monitoring procedure. So very important. Also, these agreements caused significant changes within the state public sector. Basically, all these countries introduced new ministries, new agencies, which focus solely at the approximation and adoption of the EU acquis, in line with the timetables envisaged in the agreements. And these agencies are quite new for our systems. New laws have been adopted. We can see that almost every month new laws appear within so-called European package. It very much resembles the pre-accession process, but of course without the eventual ultimate objective of the membership, but it's there. Then the agreements itself have caused significant impact on the national judiciary. It's a very interesting topic because national judiciary is a central pillar of the rule of law reform in these countries, because traditionally judiciary in Ukraine in particular, Georgia and Moldova, has been considered as the most corrupt and not reliable. Judicial process is not really transparent. And the association agreement caused so-called judicial reforms. For example, in Ukraine, complete revision of the judicial system with introduction of abolition of specialized courts and introduction of one Supreme Court with specialized chambers. And what's interesting, what actually touched upon my faculty, complete resignation of the entire Supreme Court. It happened about 2 years ago, and the public concours with, which happened for the first time in our country, to enlist new Supreme judges. And for the first time, this concours was open not only to trained judges, let's say, or prosecutors, but for academics. And some of my colleagues at my department applied and successfully went through, and it was a big deal. Your colleague nearby could, in 1-2 days, become move from career from a professor, even sometimes associate professor, and become Supreme Judge. After passing certain exams and tests, including psychological and also a screening of material assets of this person, which was very unusual too. And what's most important, what we are now, I'm now involved in this project, decisions, judgments have changed. There are more and more references to the case law of the European Court of Justice by Ukrainian judges, sometimes unintentionally. So even sometimes they mix judgments of the European Court of Human Rights and the European Court of Justice, especially related to issues of fundamental principles of European Union law and Council of Europe. But now on, in more and more references come out with deliberate references to EU law in fields of competition, public procurement, IT too. It's very important now. And you can see that Ukrainian judges now are quite eager to apply and to refer as they call it, persuasive source of reference, not as a binding source. They're not obliged, of course, but they call it was a clarification by Supreme Administrative Court, persuasive source of reference to justify certain approaches. Then monitoring, of course, is very important. As I already said, it happens once a year, but also there are plenty of other projects going on which constantly monitor state of reforms in our countries. Cross-pillar cooperation between the EU and Ukraine, it covers everything. Ukraine is basically alliance voluntary itself with foreign policy of the EU and major statements within the UN. And now it's a big, as already mentioned, big deal to actually find ways how Ukraine could participate in common defense policy. And most important, actually, agreement to touch now, it's constitutional amendments. So the agreement itself caused very important constitutional amendments in Ukraine and in Georgia. I just recently checked, Peter, you are right, there is a new Article 78 in the Georgian constitution, so-called Euro integration article. So what happened, briefly? Ukraine, the agreement itself actually triggered significant constitutional amendments. One of them amendment, which took place 2 years ago, was related to the Rome Statute, International Criminal Court. The matter is that in 2001, Ukraine already tried to actually to ratify the Rome Treaty, but the Constitutional Court of Ukraine issued decision saying that, well, we cannot do it because it contradicts our constitution in terms of independence of our judicial system. Judiciary. We cannot accept jurisdiction of international court, which would automatically become of our judicial system. It was decision of the Constitutional Court, and therefore this issue got stuck and on standby. But the agreement, association agreement, after being ratified and entering into force, contains a deliberate provision saying that Ukraine must enter and ratify the Rome Charter. And therefore, we faced a dilemma. We had a decision of the Constitutional Court and this binding decision of the association agreement. And in the end, we had to do something, and it was, of course, very significant public debate. There was the amendment, and this issue was pushed, I must admit, by the EU side very much, by the delegation and monitoring reports too. The amendment finally took place a couple of years ago, where it was said that Ukraine will accede. It's now it's in the constitution. However, Ukraine hasn't done it yet because another debate is going on. We are very much concerned with the fate of our military personnel in the east of Ukraine who are currently engaged into active military combat. And one of the policies on behalf of the Russian government is actually to raise legal issues related to the military crimes caused by Ukrainian military personnel in the east of Ukraine against a peaceful population. So, so basically, we are very much concerned that after we officially enter the Rome Statute, there could be some moves which could engender military personnel there. So it's in debate, in pipeline too. But another most significant constitutional amendment took place just recently, a couple of weeks ago, and there is a, I just quote, preamble in the Constitution of Ukraine. It now contains new provision. Confirming European identity of Ukrainian peoples and irrevocability of European and Euro-Atlantic policy of Ukraine. Yes, and it's in other provisions, they commit President of Ukraine and Cabinet of Ministers and Parliament to pursue policy in line with this preamble. Why it's being done? Actually, in my opinion, there are many opinions. It's basically to ensure that if government and ruling elite changes, Ukraine will never again go through the same Yanukovych type situation when a leader of country may abruptly raise and stand. Now on, we decide to change the foreign policy and to shift it opposite. So there is a belief that this provision would sort of stick and make foreign policy and reforms, domestic reforms, more predictable. It's of course it's another case. Probably you can contribute to the debate. And basically, I don't want to take time. It's I think it's all. Yeah. Thank you very much.
Thank you. Well, thank you, Roman, for this this very interesting presentation. And we see that, well, it's a broader sense. You spoke about association agreement in general, but when we see the effects, the impact on the legal system, we can start guessing that DCFTAs are not quite the same, and FTAs in the neighborhood, in Eastern neighborhood, at least, are not quite the same as other type of FTAs we study in the rest of the world. So now we'll move south, and for the two other presentations now. I'll give immediately the floor to Dr. Nicolas Pigeon, who works with us on the Law TTIP project as a postdoctoral fellow and who engaged himself a lot in the organization of this seminar. So Nicolas will give us a state of play of the ongoing negotiations with southern neighbors. So Nicolas, you have the floor.
Thank you, Cécile. Thank you, Cécile. First of all, as an organizer, I'd like to address many thanks to Catherine and Cyril for their precious help in the organization of these seminars. And of course, I'd like also to thank all the participants as well as the audience for being here today. It's a pleasure. Let me begin by a brief vocabulary point and by recalling quickly some elements of historical context. In the EU's terminology, the Southern Neighbourhood refers to a group of 10 countries surrounding the south side of the Mediterranean Sea, from Morocco to Syria. These countries are subjected to the EU neighbourhood policy, which, it has already been said, essentially aims at the economic and legal integration to the Union of some of its closest countries from a geographical point of view. This integration should be made on the basis of shared principles and values and give rise to socially equitable and solidarity-based economies. Besides, it is supposed to improve the people's cross-border mobility. The relations between the EU and the Southern Neighbourhood countries are quite old. There's no need here and no time to give an exhaustive overview of these political, economic, and financial historical relations, but an important step of their evolution should nonetheless be emphasized. In the late 90s, the EU started negotiating association agreements with the Southern Neighbourhood countries, the well-known Euromed agreements. The scope of these agreements, in their commercial dimension, was rather narrow, as they were mainly directed to the liberalization of movements of industrial goods. To say the least, the results of the implementation of these agreements have been critically assessed, especially on the Tunisian side. And indeed, their expected benefits remain for the most part to be seen. The several flaws of the neighbourhood policy led to its reorientation towards a brand new one, more targeted, pragmatic, and flexible, said the Commission in a communication published in 2015. In particular, the EU decided to propose to some of the most advanced countries of the region a deepening of their economic integration into the economic European area through the negotiation of deep and comprehensive free trade agreements. By opening the markets in a broader way, these international agreements are perceived as appropriate tools for the stabilization of the region, which is the new key concept of the neighbourhood policy next to differentiation and co-appropriation. Thus, on the 14th of December 2011, the Council of the EU gave mandate to the European Commission to start negotiations with Egypt, Jordan, Morocco, and Tunisia, 4 countries that are already members of the WTO. Essentially, that means that the DCFTAs have to comply with Article 24 of the GATT and Article 5 of the GATT. With Morocco, the negotiations started in March 2013, and in 2014, after 4 rounds, the negotiations have been stalled for political reasons, part of them being the Western Sahara question after the rulings of the CJEU. Meetings to explore the possibility to relaunch trade negotiations were planned for December 2018, but haven't led yet to decisive progress. With Egypt and Jordan, the negotiations didn't really begin. Only the scoping exercise seems to have been completed. Therefore, this contribution will rely essentially on the state of play of the negotiations with Tunisia. Started in October 2015, they are the most advanced and the only where legal information can be gathered. Following from the reflections that have already been made regarding the Eastern Neighbourhood, I'd like to share some thoughts based on the analysis of this information. I will corroborate first the idea that there is indeed a real specificity of the DCFTAs negotiated with the neighbourhood countries, to the extent that the EU seeks a deepening of the economic integration through a normative alignment. In other words, if the global purpose of these international agreements is quite ordinary, at least if compared to the other FTAs negotiated with the EU, the method differs. A link is established between the opening of the markets and the conversion of the third state's legal order to European Union law, especially in key economic domains. This reflection on the specific features of the DCFTAs negotiated with the neighbourhood can be prolonged. Can signs of specificity of the DCFTAs with the southern countries be identified? On the basis of a comparison between the DCFTAs with these DCFTAs with the south and the ones negotiated with the eastern neighbourhood, I'll argue that this specificity exists, but should not be overestimated. Overall, DCFTAs remain FTAs, and elements of adaptation to each country cannot conceal the common political economy logic that they convey. Finally, I will raise some questions as a conclusion. So my first point is to highlight that the economic integration in the DCFTAs is made through normative alignment. Through the intervention of Professor Van Elseweghe and Professor Petrov, this point has in fact already largely been made. Within the DCFTAs, the deepening of the economic integration of the neighbor countries is premised on the association of two main parameters. The first one, linked to their comprehensive nature, is the broadening of the scope of the liberalization commitments. I won't address this point in depth. It is quite clear by looking only at the structure of the Tunisian DCFTA that its coverage greatly exceeds the one of the trade chapter of the association agreement. Besides, in nothing but the trade of goods chapter, the parties, maybe the EU, decided to negotiate on the basis of a negative list approach. This is a significant shift, considering that only industrial products were covered by the association, are covered because the association agreement still applies. The crux of the negotiation, so, is now to identify sensitive products for which reserves to the opening commitments have to be made. And of course, the agricultural products are principally targeted here. This comprehensive approach to the negotiations does not, however, permit to differentiate DCFTAs in the neighborhood from elsewhere. It is mainly their deep coverage that makes the difference. Not so much in itself, as all the EU FTAs can now be considered to be deep, but because, I said it, of the method used by the EU with its neighbors to address behind-the-border hindrances to trade and investment flows. The method is a normative alignment obligation by which the third state commits itself to bring gradually its regulations closer to the corresponding EU law, if not copy-paste them in its own legal order. So far, several fields generated normative alignment commitments by Tunisia. Sanitary and phytosanitary measures, technical barriers to trade, custom procedures, protection of intellectual property, rules on competition and state aid, and the regulatory framework of telecom and maritime transport services. I cannot address them all, but I would like to underline some interesting features of the alignment commitments in the field of competition law and technical barriers to trade. In the competition field, the parties seems to have agreed that some practices and transactions, namely cartels, abuse of market dominance, mergers, and state aid, may be incompatible with the shared objective of a free and undisturbed competition. Insofar as they may affect trade between the parties, these practices are incompatible with the agreements. Basically, as in EU law, the applicability of these commitments depends on the exercise of an economic activity. The first interesting point here is that all these notions have to be interpreted in accordance with EU law, that is to say, on the basis of the criteria stemming from the TFEU, the case law of the Court of Justice, secondary law, and all the soft law instruments employed in the EU legal order. The second point is that a specific provision is devoted to the effective implementation of this free competition objective. However, the obligation that this provision contains are only addressed to Tunisia. Within a period of 3 years, the Tunisian government has to adopt, or otherwise to maintain, an entire set of regulations able to ensure the effective implementation of the competition chapter of the DCFTA. But this goes further. First, Tunisia has also the obligation to establish or maintain an independent and efficient competition authority. Second, it has to comply with several procedural standards when implementing its national competition law. The third point that makes the neighborhood DCFTAs very specific is that the general dispute settlement mechanism has jurisdiction on some part of the competition chapter. This is quite extraordinary if compared, for instance, to CETA or the EU-Japan EPA. Indeed, while the entire chapter is actually excluded from the scope of the jurisdiction of the DSM, the violation of the implementation commitments of Tunisia can nonetheless be subjected to it. Regarding technical barriers to trade, the same kind of logic is applied. Tunisia undertakes to gradually bring its regulations closer to the one of the Union. This entails an integration of the acquis, of course, but also all the administrative and institutional reforms necessary to the proper implementation of the agreement. If needed, Tunisia has also the obligation to put into place efficient and transparent administrative structures. As in the competition field, some kind of surveillance mechanism is established in order for the EU to monitor the Tunisian alignment process and thereafter the evolution of Tunisian laws and regulations. It consists mainly in a regular exchange of information with the EU. Moreover, Article 6, paragraph 8 of the TBT chapter indicates that alongside the transposition of EU law, Tunisia has to repeal any national norm in conflict with the EU ones and to cease immediately their application. These two domains of alignment show that rather than the integration of the third state into the economic European area, the DCFTAs have the effect of extending its boundaries to the exclusive benefit of EU law. For the neighbor, the normative alignment is an obligation that is part of the overall negotiations and that gives no chance to participate effectively in the drafting of the norm. How to square this with the co-appropriation principle that is supposed to drive the neighborhood policy remains to be seen. Besides, this external policy may have significant costs for the third state, depending on the extent of the reforms that appear necessary, but also for his economic operators that have to adjust their production process in order to have access to the EU market. And surely this gives an economic advantage to the European companies on the market. This is why the EU devotes great amounts of money to the technical and financial assistance programs aimed at facilitating the normative alignment. And here is another peculiarity of the treatment of the EU neighbors. Now, is there a specificity of the DCFTAs negotiated with the southern neighborhood countries? In order to identify such a specificity, a comparison has obviously to be made with the Eastern agreement. But then, all depends on the level of comparison. In a very general perspective, they might all look quite identical. Are the same, they are all deep and comprehensive. Their institutional structure, the institutional structure, that they establish will probably be very similar. And the settlement of disputes by arbitral panels is designed in many ways just like the WTO dispute settlement mechanism. If one looks, however, on a much more narrow scale, they might appear as completely different agreements. For instance, the linguistic transcription of protected geographical indications is of course not the same in the Georgian Association Agreement and in the Tunisian one. That is to say that the choice of the level of comparison is inevitably arbitrary and can hardly pretend to have any scientific significance. Still, I'll take the risk to make a comparison under the guiding hypothesis that the Eastern neighborhood is probably much more subjected to the internal market logic than the southern one. I find arguments for this in some clear distinctive features that I will address first. Afterwards, I will sketch domains of uncertainties where the comparison remains inconclusive. Finally, I'll address a domain of similarity between the agreements which tend to contradict my hypothesis. One of the main distinctive features of the southern DCFTAs is the fact that they will probably include a chapter on the protection of investments and therefore the new investment court system, if of course the CGEU finds it compatible with EU law and if Tunisia accepts it, which is not certain considering the ongoing debate on the issue. However, the standards of investment protection, as well as the infamous investor-state dispute settlement mechanism, are excluded from the scope of the Eastern Association agreements. Besides the fact that they contain no chapter on investment protection, they all explicitly exclude the backdoor integration of such legal regime through the implementation of the national treatment at most favored nation treatment clauses. Considering the integration of the eastern neighbor countries to the external edges of the EU legal order, It is tempting to analyze the absence of an investment protection chapter in the DCFTAs as a proof that the EU does not consider them as third states like the others. The extent of the normative alignment implied by the Eastern DCFTAs and the association of the CGEU to the settlement of disputes by a preliminary ruling procedure might be elements of explanation for this. In a way, the ACMEA rezoning could maybe find its place in the relation with the Eastern neighbors, but I can come back on this point later on. This exclusion could only be temporary. All the Eastern DCFTAs contain a review clause indicating that the parties can reopen negotiations in order to include investment protection provision and ISDS. For now, however, investment protection with the Eastern countries relies on the application of the member states' BITs. The EU DCFTAs contain only liberalization commitments. The two domains of uncertainties that I'd like to address are the protection of geographical indications, entry and stay of persons for business purposes. I'll say just a few words on each one of them. The system of protection of geographical indications, it's pretty much the same in all the agreements. I won't enter into details as it is quite complex, but I'd like to underline that the Eastern neighbors have agreed to protect in their markets almost all the European GIs. That is around 3,000 GIs that are listed in about 150 pages in the annex of the DCFTA. Will Tunisia accept such a comprehensive protection? Or will the European negotiators focus on around 200 GIs like with other third states, the Asian ones notably? Whatever the results of the negotiations with Tunisia will be, the comprehensive protection of the European GIs that derives from the Eastern DCFTAs clearly shows that these markets are an extension of the EU internal market from the specific perspective of these intellectual property rights. The temporary entry and stay of persons for business purposes is one of the key aspects of the negotiations with Tunisia. This mode of services supply implies a right to cross-border mobility only for specific categories of persons, mostly the highly qualified ones. In order to benefit from these kinds of commitments, these persons have to be linked to an economic activity, be it an investment or the supply of a service. This is a field of great asymmetry between the EU and Tunisia, since Tunisian natural persons find it very difficult to access the EU market, even for short stays, whereas it is very easy in the opposite way. Considering the state of play of the negotiations, there's not much to say on this point for the moment. But it will be interesting to follow the way these commitments will be articulated with the EU immigration policy, especially through the negotiations of visas facilitation agreements. It has to be underlined here that these commitments do not prevent the parties from applying measures to regulate the entry and temporary stay of natural persons into their territory. In particular, the sole fact of requiring a visa for natural persons from a certain country and not for those of other country is not contrary to these obligations. So I'll be very interested to have information on the way this chapter has been negotiated with the Eastern Neighbourhood, particularly regarding its articulation with the visas agreement. Finally, the competition chapter is a good illustration of similarity between the Tunisian and the DCFTA and the Eastern Association Agreement. As I said before, a crucial characteristic of the competition chapter is the alignment of the third states regulation on EU law that it commands. On this point, Eastern DCFTAs and the Tunisian one are very similar. Besides, regarding state aid, all the neighbor countries are generally considered to be areas where the standard of living is abnormally low and where there is serious underemployment, according to Article 107, paragraph 3.a of the TFEU. If this rule is sometimes just of temporary application, it allows considering state aids compatible with the agreement in an easier way. Regarding the exclusion of the competition chapter from the jurisdiction of the dispute settlement mechanism, one key issue remains to be decided in the Tunisian DCFTA. In addition to the implementation obligation, the Eastern neighbors have accepted the submission of the state aid provisions to the jurisdiction of the DSM. Will Tunisia accept it too? For now, disputes on state aid issues have to be resolved through consultation in the Association Council. So my conclusion now. The new European neighborhood policy rests on three main principles: differentiation, co-appropriation, and stabilization. DCFTAs can be considered as appropriate tools for differentiation. True, it is probably easiest to adjust the reciprocal commitments on olive oil quotas than on fundamental values, such as human rights and the rule of law. Besides, delays for the implementation of certain sensitive obligations can always be agreed in order to accommodate the demand for progressivity of the third state. In other words, the classical techniques of international economic law seem suited for the differentiation purpose. Regarding co-appropriation and stabilization, however, the DCFTA with Tunisia might not prove to be the best mean. It can reasonably be adopted whether allocating money to compensate the cost of the alignment towards European norms fits properly with the definition of appropriation. In addition, the stabilization through liberalization policy has already proven to be very random. By looking through the lens of the DCFTAs, the EU seems to pass from an association policy including a trade chapter to an association policy via trade. In this regard, despite the specificities of these agreements in the neighborhood context, a form of normalization of the neighbor countries in the EU external action can be noticed. The case of cross-border people's mobility is quite illustrative. On one hand, the EU negotiates visa facilitation together with readmissions agreements. On the other hand, in the framework of the temporary entry and stay of persons for business purposes commitments, the EU only facilitates cross-border mobility for the most qualified and economically active workers. This dual policy can also be observed with other third states outside the neighborhood framework. Thus, DCFTAs, are they instruments of the neighborhood policy? Or should we rather note now the absorption of the neighborhood policy into the common commercial policy? Thank you for your attention.
Thank you, Nicolas. We'll now hear, last but not least, our colleague, Professor Catherine Barrault, who I would like to thank sincerely for being here today. And she kindly accepted to step out her comfort zone and enter in a dialogue with public law academics. And this is really a nice opportunity for us to have her point of view of what we've been discussing this morning. So, her presentation will be on, will focus on the EU-Tunisia relationship and the question about asymmetry or balance relationship, I believe.
Thank you, Cécile. So I will start in a rather classic way by thanking the organizers for allowing me to take part in this very interesting and useful project. Thanks to the former speakers, I can start directly my presentation and cut some paragraphs. EU DCFTA's proposal to Tunisia is based on three principles: asymmetry, to take into account the difference in the level of development between the parties; gradual opening up, accompanied by the necessary support to strengthen the competitiveness of the Tunisian economy; regulatory convergence in the priority areas to be identified by Tunisia. Each principle is intended to contribute to the balance of EU's relationship with its partner. This presentation will only deal with the contribution of asymmetry, because it has a particular importance in these negotiations. The Tunisian economic situations requires adjustments. The asymmetric approach is used to describe this situation. It implies that Tunisia's obligations will not mirror those of the EU. The trade liberalizations and regulatory convergence aimed by this agreement will adapt to the priority chosen by Tunisia and will go hand in hand with the ongoing reforms by taking into account specific characteristics of Tunisian socio-economic development. The purpose of this presentation is to determine which asymmetries are really taken into account in the draft proposals and to compare them with those that seem desirable to stakeholders. The association agreement already was based on an asymmetric approach. Yet, Tunisians consider that their country has not benefited enough of it and has even been a victim of this agreement. They are vigilant to ensure that this principle is taken into account both in EU's proposals, Part 1, and in the conduct of the negotiations, Part 2. Part 1, asymmetry in the proposed text. From studying the draft proposals, it appears that these DCFTA proposals can be classified into 3 blocks. A block of proposal based on asymmetry in favor of Tunisia, a set of proposals based on the principles of international trade law, my opinion, a block of proposals in favor of the EU. Given the limited time available, I won't give any details to justify this, but you will be welcome to ask questions later. The following proposals, first point, are presented as being adapted to Tunisia's particular situations. The relevant texts are goods, technical barriers to trade, digital trade, trade and sustainable development only. The second block of text shows that asymmetry is sometimes replaced by the usual provisions of free trade agreements. Services and investment, investment protection agreement, protection of intellectual property, consent procedures, transparency rules. The main topics are in this list. And some of the proposed texts are in favor of the EU. Energy and raw materials, small and medium-sized enterprises, sanitary and phytosanitary measures, public procurement, rules on competition and state aids. One draft proposal seemed to be difficult to classify. It reveals the ambiguity of the principle of asymmetry. It's a proposal concerning agriculture, processed agricultural produce, and fisheries produce. The text proposal contains the following sentence. The DCFTA aims to achieve a higher level of ambition in trade liberalization, while taking into account sensitivities of each party. The proposal also contains the EU's commitment to support in upgrading the priority sectors identified by Tunisia, but within the limits of available resources. Based on these draft proposals, negotiations confirm that the EU's South partners is calling for more asymmetries. Asymmetries confirmed in the negotiations Part 2. In the context of the negotiating rounds, the Tunisian party has often called for more attention to be paid to the specific Tunisian characteristics. In the public dialogue in Tunisia, there has been a clear demand for a stronger asymmetrical approach. According to a Commission notice, both parties are receptive to the calls of the civil society to be involved in the process of negotiations. This leads me to address the reactions of the Tunisian society in my second point. So in the first point, I will talk about the asymmetric approach in the rounds of negotiations. Reading the 3 rounds joint reports, teaches us a lot about the asymmetric approach. On many occasions, the Tunisian party has pointed out the inadequacy of the text on this subject. Given the limited time available again, I will focus my remarks on just 2 points: the agricultural issue and the visa issue. And I won't speak about competition issue. The first round of negotiations was held in Tunis in 2016. The discussion opened on the negotiating parameters for agricultural and fisheries sectors. Tunisia requested clarifications on the protection of the European market, on the EU's position on asymmetry, and on the need to take into account the difference in the level of competitiveness between the EU and Tunisia. The EU, for its part, reiterated its commitment to provide technical and financial support to Tunisia in these areas, but within the framework of the available cooperation programs. The visa issue was addressed in connection with the text on services and investment. Tunisia recalled the importance of this sector in terms of added value and job creations. The report shows something like a disagreement between the parties. Tunisia stressed the importance of certain principles, such as progressive opening and asymmetry in the liberalization process, as well as the need for accompanying measures to ensure gradual convergence of regulation and sustainable development. With regard to the temporary presence of natural persons for professional purposes, the Tunisian party underlined the importance of facilitating access for service providers to the territory of the EU for the effective liberalization of services. The John report only indicates, in answer, the EU took note of all these comments. Nothing else. After that, an important technical meeting was held in Brussels in 2017. During this meeting, Tunisian requests for mobility were raised twice. First, on trade and sustainable development, the Tunisian party discussed issues related to the mobility of investors and professionals in this area. Secondly, with regard to services and investments, discussions focused on aspects related to the mobility of service providers and the mutual recognition of diplomas and qualifications. By this, the Southern partner showed that it attaches great importance to the removal of obstacles to Tunisian service providers' access to the European market. The EU offer only proposes, first, that admission and temporary stay are granted for a maximum period of 3 years for managers, executives, and experts, 1 year for trainee employers, and 90 days over a 12 months period for visitors and business travel for settlement purposes. And nothing is said about work permits, which are essential for Tunisian service providers. Secondly, the EU's offer proposes that there may be restrictions on the total number of natural persons that an investor can employ as business visitors and persons undergoing a temporary intra-group transfer in a specific sectors. This can, of course, only be applied to the Tunisians. The report doesn't say whether the EU has responded to this request. Now let's talk about the second round of negotiations, which took place in Tunis in May 2018. Tunisia initially proposed to extend the scope of the agreement to cover mobility, innovation, and technological transfer, and to provide for substantial support and accompanying measures. In response, EU while confirming its commitment to support Tunisia in its successful political and economic transition, stipulated that the issue of mobility is being addressed in the context of the visa facilitation and readmission agreement only. EU added that steps have even been taken to ensure synergy between the two negotiations. At the same time, the discussion seems to have been tense on agricultural sector. Without calling into question the principle of asymmetry as such, the discussions on the exact terms of the transition periods for liberalization on the Tunisian side has not been concluded. One more time, Tunisia insisted the importance of the EU support for the upgrading of this sector and the usefulness of providing adequate and consistent accompanying and assistance measures for this purpose. For its part, EU recalled, first, the forthcoming competitiveness and export support program, which will include an important component on upgrading the agricultural sector. Two, the underway program to boost investment and modernize agricultural holdings. In the last instance, the third round was held in Brussels in December 2018. The joint report shows strongly held positions. Tunisia suggested that the future agreement should reflect the strategic nature of its relations with the EU. Tunisia considered that the agreement scope went far beyond trade aspects. Tunisia took the initiative to promote the usefulness of ensuring the effectiveness of concessions already exchanged according to an asymmetrical and progressive approach. Tunisia also made counter-proposals regarding the services and investment in time to enshrine the principle of asymmetry through greater flexibility, taking into account the sensitivity of certain sectors and the competitiveness gap between the two economies. Other Tunisian proposals focused on economic equity, effectiveness of the implementation of commitments relating to the movement of natural persons as service providers, establishment of appropriate mechanisms for the reconnection of qualifications and diplomas, and the removal of obstacles to access to the European market for Tunisian service providers. Once again, EU responded that the issue of mobility will be only addressed in the context of the visa facilitation and readmission agreement, in synergy this time with the discussions on the movement of service providers. Small progress. EU stated that a meeting between Tunisia and the European Commission and EU member states took place on 24 October 2018 in Brussels. And these consultations will continue. When, where, we don't know. The parties notice that a difference of opinion remains on the exact terms of asymmetry in favor of Tunisia in the agricultural sector. As previously, Tunisia recalled the importance of support for upgrading, particularly for small and medium-sized farms, and for the competitiveness of the agri-food sectors. Surprisingly, the report doesn't mention EU's reactions. Despite the slow progress on these two main issues, parties were able to agree on a timetable. Meetings with civil society representatives in Tunis next week. A fourth round of negotiations, preferably in the spring in Tunis. Exchange of proposals and counter-proposals before the summer, if possible, followed by a debriefing meeting at political level. This third round was marked by a stronger involvement of the Tunisian party. The explanations lies in the fact that Tunisian negotiators were helped by Tunisian stakeholders now involved in the negotiations to support the asymmetrical approach. Point 2. The asymmetrical approach in the Tunisian society. the agricultural issue and the free visa question are extremely important for Tunisians. Respect for asymmetry and gradual opening up rule is strongly advocated. Many Tunisian organizations think, first, that behind the beautiful facade of cooperations, objectives deviate from the social progress expected from such agreements. And two, that the use initial proposal reflect asymmetry to the benefit of the European companies. Calls have been made for the agreement to be truly conducive to equitable development, for negotiations to be transparent and accessible to citizens. Effectively, it's done. And for an independent evaluation of the agreement under negotiations. For 3 years, Tunisian experts denounced the lack of proposals from Tunisian government during the negotiations. In an independent study published in October 2018, concerns were raised about the opening and massification of investments under the agreement. And these fears are even more pronounced in the agricultural sector. It's to be feared that many farmers will disappear in the face of European competition once this study. UTAP, an important farmers' union, called on the government to be more vigilant about signing this agreement. The farmers' union stated, this is where the upgrading of the agricultural sector, provided for in the text, comes in. All that remains is to guarantee it. Even the Minister of Agriculture takes a critical view on the negotiation and states publicly that the agreement will not be concluded quickly. Furthermore, there can be no question of opening up services without flexibility on free visa. As the EU proposal stands, a Tunisian entrepreneur could apply for an electrical installation contract in Europe. To provide his services, he needs to come to the member state concerned himself. His engineers and project managers must support him. For each of these, a visa will be required. The condition and time frame for issuing the visas will vary. The situation will be unfavorable for his company, and he will have little chance of obtaining a second contract. On the other hand, European entrepreneurs easily enter Tunisia with their teams. In addition, Tunisia's inclusion on the list of tax havens or countries at risk for money laundering and terrorist financing has created difficulties for Tunisian companies. They find hard to set up subsidiaries in Europe, especially in France, where opening a bank account is a long and complex operation. Stakeholders forwarded this question to the negotiators for the third round, but we have seen that they were not heard. Now, the economics interests and the experts want to build a Tunisian counter-offers from the sectors for the first round of negotiations. Next week, we will learn more about it. Finally, two asymmetries in favor of the EU are of concern to Tunisian society. First, initial proposal for DCFTA came from the EU. The Tunisian party can only respond and make counter-proposals. But in a negotiation, a considerable advantage is granted to those at the origin of the text to be discussed. Secondly, there is no timetable for negotiations. The imbalance is due to the fact that the EU doesn't have a good economic interest in Tunisia. The European proposal for a privileged partnership simply aimed to consolidate the EU's economic area influence. The duration of the negotiations, therefore, does not matter. In contrast, this agreement is not an option for Tunisia. The economic situation in this country requires rapid adjustments. the resurgence at the end of 2018 of major economic unrest in the town named Catherine, after that of 2011, shows the urgency to act. The EU does not expect any specific improvement in its situation as a result of this agreement. Tunisia does. The agreement is expected to be signed in 2019. Given the proximity of the Tunisian and European elections and the inherent risk of a change of majority in Tunisia, of a change of behavior towards Tunisia in the future Commission, the timetable has been shorter than anticipated. Under these conditions, will it be possible for the parties to reach a balanced agreement containing a satisfactory dose of asymmetry? To conclude, I will quote these words from Jess Morgan. There is no panacea for solving the fundamental problems in the southern neighborhood, and economic development in itself may not do the job. But without it, things are likely to get even worse. Success stories are badly needed. Thank you for your attention.
Thank you, Catherine, for this presentation, and your conclusion probably cut one of my questions I had to ask you, so you answered already. So now we are opening the debate with everybody who wants to start with a question. I think if you're not too keen on speaking English, that some of your questions might be asked in French. That's if it's easier for you, it's something you can do. I think won't be a problem for for most of us, and we can translate to our Ukrainian colleague if it's him you want to him you have a question to ask. Anybody wants to start?
I have a question for Peter or maybe Roman. I don't know. I will move a little away from trade, and you both spoke about the legal basis of the association agreement, and I wanted to have your thoughts about the case law, the Kazakhstan case law, and the impact of this case law on the legal basis for future association agreement. Especially if we take into consideration the fact that the court in its judgment says that association agreements are a specific category of international agreement. So do we have to consider that this judgment is a very specific for association partnership agreement, not cooperation and partnership agreement, or do we have to have a broader interpretation and consider that CFSP legal basis should not be used for association agreement in the future? I don't know if you want to answer.
Do you have other questions right now? We can take a set. One question at a time.
Yeah, thanks for the question. I think, I mean, if you follow the logic, it seems that it has some consequences, because it's very difficult, in my view, to argue that CFSP part of the association agreements, like with the Eastern neighbors, is to be separate from the entire agreement. I mean, it's an integral part of the entire agreement. So if you apply the traditional center of gravity test and then the absorption doctrine, in the way as it was also developed by the court in the Kazakhstan case, it seems to me that you might make the claim that 217 as a legal basis might absorb the entire, other provisions, so that it was not needed to have the addition of the CFSP legal basis, as it was done with the agreements with Ukraine and Moldova and Georgia. This seems to be the kind of logic which is the logic behind the nature of association agreements, that they are comprehensive, that they provide for a specific comprehensive framework for relations with third countries, including the entire scope of EU competences, including the CFSP part. Of course, this is a kind of in a certain extent far-reaching, because it goes against the idea that CFSP is really to be regarded as something special and separate. But that seems to be the kind of trend of, Christophe also referred to it when we were in The Hague. It seems to be this kind of trend where the court tries to minimize the separateness of the CFSP and considers it as just an area like the other areas of competences. If you follow this logic, then I think it is not necessary to have the addition of separate CFSP legal bases. So that seems to be the kind of trend or evolution. But
yeah, I fully agree with you. But I think the court in its judgment stressed really out that the specificity, the fact that association agreements are a specific category of international agreement. And if you read the judgment, there was no need for that.
But the judgment is not about association.
No, it's not. But the court made a comparison between partnership agreement and association agreement, and I wasn't really sure that in its reasoning it was really necessary to specify the category of association agreement. So my question was, is there a specific reason why the court did that? And you wanted to say something?
Just an additional point to muddy the water. If you connect this case law with the case law in relation to several association agreements whose implementation was contested by the UK Commission or UK versus Council, there is one of those judgments where the Court of Justice admits that although the legal basis for association agreements is deemed to be used in a comprehensive manner, the Court favours the use of the specific movement of, what is it, Article 48, I think?
Social security.
That's right. For the purpose of implementing that association agreement. So that goes exactly in the opposite direction. So that if you follow this UK versus Council case law, you would then agree that the CFSP legal basis might be justified. But in Kazakhstan, your court seems to go the other way, applying the good old center of gravity.
yeah, but I think there is an important difference between the general conclusion of on the legal basis of the for conclusion of the agreements and this particular issue that was at stake in the UK versus Council cases, because there it was rather specific. It was about the extension or amendment of annexes to the agreements related particularly to social security coordination for persons. So if, there the decision, in my view, was, or the question in those cases was, what is the legal basis for that particular issue, meaning upgrading of the agreement, general agreement, but only in relation to aspects concerning movement of persons. So if you apply the same logic, center of gravity test, what is main purpose, in that case, it was only about persons. If the question is about the legal basis for an entire agreement, then yours, to apply the same logic to the CFSP, CFSP is only one of the provisions of a comprehensive agreement. So if you apply it to the agreement in general, you would not need to add the CFSP legal basis. Whereas if you would have, I think it depends upon the question and the concrete issue. If it's about the question of legal basis of an entire agreement, I don't think you need to add the CFSP legal basis specifically if you follow the court's logic in Kazakhstan. But if you have a question concerning the adoption of a particular decision which has a CFSP related, then,
So what you're saying is that we could have an
Mhm.
That agreement could be based on Article 217.
Mhm.
But if further down the line there is a particular implementation of the CFSP part, however ancillary, then you would use the CFSP-related procedural arrangement.
Mhm.
Isn't that? Yeah.
It,
It's an
well,
interesting.
I think if you combine both, I mean, both lines of case law, the case law you referred to, UK versus Council, that seems to be the implication of that line of type of case law. That if you have a particular question, which is about the adoption of a position or the certain amendments, which only concerns, let's say, CFSP issues, then I mean, the focus, center of gravity will be the CFSP issue. So it means you need the CFSP legal basis for that particular specific decision. If it's about an agreement in general, you apply the same, I mean, in both situations, you apply the same criteria, the same tests. It just depends upon the, let's say, the area or the topic or the particular document or proposal to which you apply the same test. If it's an entire agreement, I mean, CFSP is just one of the several parts, so it's logic that it's not to be added as a basis. But if you apply the same test to a proposal which only concerns CFSP, then it seems that if you apply the same to only that little scope, that proposal, then you might argue that it has to be the CFSP. I mean, this is, in my view, what the court did in these UK versus Council cases, because there the proposal was the adoption of a position regarding amendments that concerned free movement of persons. So it did not say it should be 217 because that's too general. It should be the specific one. But I mean, this is perhaps how to connect both lines of case law.
I want to add, it also probably clarifies that with regard to the dispute on application of Article 8, it actually shows that there is no room for Article 8 anymore within the association agreements to some extent. And also, it's interesting to refer to the Simutenkov, which is PCA with Russia, it was compared with association agreements. And now this judgment Kazakhstan shows that its association is definitely a different one. It's also kind of put a dot on this interesting picture. Yeah, question mark, yeah.
Well, I have if nobody has questions, I do have questions. I was interested by what you said, Catherine, about the implication of stakeholders and the role of civil society in Tunisia. It seems that, like we heard in some other FTAs negotiation, civil society is very much involved in the processes. And I was wondering, it's more like a general question to the panelists. Is the civil society in Tunisia, but also in other, very much in favor of the DCFTA negotiation, the FTA negotiation with the EU? And when the negotiation occurred in Eastern neighbors, was the civil society very much aware of what was going on, very much involved in in the process of negotiating, or is it I don't know? Is there a general trend in the negotiations of FTAs that civil society very much tries to influence the negotiation process, or are there specifics? And
j'ai un complément. Qui est la société civile et comment sont sélectionnées les personnes qui sont impliquées au titre de la société civile?
any other questions related to this topic or other topics?
I have a question for Professor Peskov about the reception from the Ukrainian part of the referendum, the Dutch referendum, and what was the reaction of the Ukrainian government and the Ukrainian civil society, and did it create a fear or an opposition to the towards the European Union, because the negotiation was opposing this agreement might have, if it had something to consider in
Okay, can answer first. So, of course, I'm not Tunisian, and I've spoken this morning because I am the vice president of an international association called EOMED, and I'm working on digital development with Tunisia, so I have many friends and colleagues I work with. So academics are playing an important role in the negotiations. They are in favor. A consultation, public consultation, has been organized in 2016 by the EU. 60 responses, 60. From France, from Tunisia, from Morocco, from everywhere in the world, only 60 answers. So, well, it's small. When I spoke about Tunisian organization, I was speaking about NGOs and civil society organizations like labor unions, farmers unions, and entrepreneurs unions. The experts are, well, they are coming from academic world and maybe from foreigner organizations. ATTAC has an important role. They help a lot, maybe not in the good sense. So the Tunisians, but it's about educated people, graduated people, post-graduated people, not the man in the street. Educated people are in favor of this agreement because there's no other solution. But if you're lucky and if you can speak with ordinary people, a lot of them didn't hear about the agreement. And some who are involved are against this agreement because the association agreement was a deception. So results are not good. That's a fact. Thank you.
Thank you for your questions. So replying on civil society and the impact on the negotiations on association agreement, I must admit that the impact of the civil society was very much limited. The negotiation process took place behind the closed doors, with there were so many complaints, even not from the civil society, but from the business communities, and especially taking into account that the agreement was very much about the DCFTA. And my personal opinion is that the association agreement with the DCFTA part of it, as it stands now, it's a product. It reflects political status quo which was in existence in 2013-2012. It's already outdated, and it didn't reflect interests not only of business community but also the civil society. Since now more and more disputes are being raised, this issue is on agenda because business community says, well, they didn't take part in the negotiation process for many reasons, mainly because the previous government, the Yanukovych government, was very much saw the agreement as a tool for selected business communities and circles to enter, very importantly, simultaneously, the European market and preserving its access to the Russian market. But it didn't work out in the end. With regard to the definition of the civil society, it's a very good question. There is no definition, and it's very difficult to define. However, as in many issues related to the pre-accession process, the EU is trying to arrange and to clarify this issue. There is a provision in the association agreement saying that the part of the monitoring process, there's a special article on the civil platform, which is quite new. And the EU has been quite efficient in sort of organizing, shaping the civil platform and forming, at least formally, the civil society. I've been briefly engaged into this activity. The civil platform was formed kind of a organized forum for selected, unfortunately. Not everyone can join this platform. NGOs, experts and civil leaders to discuss the progress of the implementation of the agreement. There is very coherent funding policy on behalf of the EU, and they're quite selective whom to support and how. So there is a whole system built up by the EU side in creating this civil platform. They're quite well organized. There is hierarchy, different focus groups related to different chapters of the agreement, and they meet from quite regularly. I wouldn't comment on quality. Unfortunately, it's not always experts are present at these forums, but they certainly call to represent certain other point of view which can be taken on board while drafting the annual reports on implementation of the agreement. So basically it's governed from a shadow side by the EU, and it's in existence. I think the same process is going on in Georgia and Moldova, I guess, but in Ukraine it's quite visible, so it's a well-established formal structure. And last question on the Dutch referendum. It's a very complicated question because me and Peter, we actually were engaged, we were contacted by the Maastricht University, yes, to take part in the campaign. So there was campaign, as you know, pro and contra, and it was a very typical ivory tower versus populous tower battle. So we was somehow University of Maastricht asked us to contribute. They got money from the state to campaign in favor of the agreement. So what they actually devised only is to draft a book to explain advantages of the agreement and no danger for the Dutch society. We drafted a chapter to explain that the agreement is not about Ukraine joining the EU in the near future and taking some money. And what we learned, other part spent them funds on investing into toilet paper project with the sign no EU-Ukraine association agreement. Apparently it worked better and achieved its result. So it shows different visions and how it works. But if we talk about Ukrainian perception of the Ukrainian society, of course it was quite negative, but not so much. Actually, I must admit that the whole campaign, all these unfortunate events related to the Dutch referendum were quite well managed by the EU side. All steps which were taken, I think they were quite reasonable. Behavior of the ruling coalition in the Netherlands, Rutte, he was quite certain that he would be able to overcome this problem in case he's re-elected, and how it happened. There was a very quite known declaration. It was a declaration by the European Council. Yeah, what was the status of the document?
Not by European Council, but
European
member states.
Member states. It was a sort of declaration. It was declaration
Yeah.
on nature of the agreement, which was again well drafted and basically all true. All true, but I think it didn't. Well, it was okay. It played its role, but what another angle of this story? This Dutch referendum somehow was quite actively, because I monitor mass media not only in Ukraine but also in Russia, and it was quite well exploited in Russian media. It was displayed like pictures that all losses, all sacrifices undertaken by Ukrainian side actually led to this rejection on behalf of the EU member state of its European ambitions. And also there was the element that Dutch voters were influenced by quite extensive media campaign showing. There was a scandal with stolen Dutch paintings which apparently end up in the east of Ukraine, on the Ukrainian territory. There were reports about Ukrainian nationalistic battalions. So it's actually all this story was quite actively used, exploited in the course of the hybrid information warfare, I would say. It was a part of the entire campaign. So I think it was it's a very interesting side of this referendum to be deserved to be studied. But somehow in the Ukraine there were some funny memes about that will not buy Dutch tulips anymore, and will not eat Dutch French fries, whatever. Is it correct? How to say it? Yeah, but it was just, it didn't go too far. So it didn't stay for long. So, but it's a very interesting part of the story. Okay.
Any other questions?
I just wanted to add little things about civil society. I think we could temper the idea that academics are in favor of the DCFTAs in Tunisia. Actually, in the Tunisian Economic and Social Studies Institute, important critics have been made to the agreement. So I think the situation is a bit more mitigated. And we also, the information that is available shows that in Tunisia, the milieu d'affaires, business groups, and the trade unions share a common vision about the agreement, in the sense that there's some kind of fear about what it may bring in Tunisia, especially due to the advantage that the European companies will have on the markets, due to the fact that they are already accommodated to the norms that will be exported. So, and maybe this is some kind of specificity, because the agreement between milieu d'affaires and trade unions is, well, maybe some kind of specificity there. And the last thing on this topic is that civil society has become a political important issue for the EU, because especially in Tunisia, the EU devotes, again, important amounts of money to sell the DCFTA as a good thing. So the communication issue and the impact on the EU discourse on the civil society has become an important issue. So just
Christophe, think you had a comment or a question?
To Roman's point, I was interested to hear whether this whole Dutch saga of ratification has damaged the, one thing, the EU's reputation in Ukraine, and more specifically, the potentially positive attitude that Ukrainians may have had in relation to the agreement itself. I know it's difficult to assess, but I'm interested in figuring out whether in the press or among academics, among business people, there was whether that saga introduced also a level of uncertainty as to the credibility of the EU in terms of delivering what it promised in the agreement.
Yes, of course. It was a kind of a bit of cold shower, but it wasn't the first cold shower. We also remember stories, a situation immediately after 2005, so-called Orange First Revolution, when newly elected President Yushchenko was already saying, I'm about to apply and we are going to seal the deal. And it didn't go to anywhere, just to the Eastern Partnership arrangement, which didn't satisfy very much. So it wasn't the first time, but it was a very good reminder that we perfectly realized that if this referendum had happened in other EU member states, even in France, as a referendum, we wouldn't be sure that it would be accepted. I don't know. I have a feeling that this result could have happened in quite a few old established EU member states. So it's not only the Netherlands which could be blamed. It was a product of certain political environment, pre-populist arrival environment at that time. It was the year 2016 when the referendum took place, yeah? So it's, but your question relates about damaging reputation of the EU. I would answer no. Why not? Because recent presidential campaign and forthcoming parliamentary campaign in Ukraine as well as in Georgia to some extent, but not Moldova. And we'll see about Moldova later this year, because if you know the situation in Moldova, Moldova is only one Eastern Partnership country with association agreement which acquired the observer status in the Eurasian Economic Union, which runs contrary to the spirit of the association agreement and the policy of, well, its idea. It's a very interesting case. And the forthcoming parliamentary elections in Moldova will actually show whether they actually, one of the parties which are going to run said that we are going to denounce the association agreement at all in Moldova and join the Eurasian Economic Union. So it's situation there is much more complicated, and we are going to see what's going to happen. They have their own reason for it, and one reason that corruption wasn't eradicated, and the recent scandal in London when son of a former prime minister actually entering a British university started with acquiring a house in Chelsea and buying 1 million Bentley, whatever. It was his start of academic studies, so it was raised so many questions, so he was even arrested under trial in Britain. So it's very complicated situations there, not like in Ukraine. But in Ukraine, reputation wasn't damaged because still our political parties hijack the issue of European integration as a part of their campaign. Almost all political candidates, they sort of seem pro-European. And for example, just by chance, I opened recent survey study. There was a recently study conducted. What's going to be a foreign policy of a newly elected Ukrainian president? There are now 50 of them who are running for the office. We are going to elect them in the end of March. This survey shows, it just was conducted recently, that 45% of Ukrainians consider that the new president must continue and follow the course of the European integration. 45, with the following division: 70% in the west and 34% in the east, which is actually not bad figure for the east, by the way. In the past it was worse. So basically, there is more or less quite strong belief that future president as well as ruling party will follow this course. How far it will go, it's not clear, but I think I don't see very much influence of the Dutch referendum. It's already part of the story. There are other issues which have been really debated, and one of the issues, the most hottest issues, is actually implementation of the trade part of the agreement, so-called timber case. If I just can briefly elaborate on this issue, or I'm sure you've heard about it. The Carpathians part of Ukraine, it's mountains covered by wood forests, and it's known that it's been heavily cut, eradicated by local population, and forest being sold to the EU, mainly to Poland. And there is a belief, there is a moratorium imposed by recent government a couple of years ago to export any timber to the EU, to ban any kind of export in order to preserve the forestry. And the EU side, especially the EU delegation in Ukraine, they are very much against, and as they rightly say, it runs against the letter of the DCFTA. So Ukraine is not in position to impose unilaterally ban on exporting certain products to the EU. They must do it by other means, using the WTO structures and so on. So now it's a big debate, and different political parties, they hijacked this issue, saying that, look, basically the EU is trying to exploit. They don't care about preservation of forestry in Ukraine. They want us to sell. However, there are recent decisions regarding to push in Poland, say about opposites, that they do everything possible to preserve forestry on the territory of the EU. So it creates some kind of public debate, and creates quite some political parties try to use this issue to build up a negative image of the EU in terms of implementation of the agreement. And it's most likely this issue is going to be first issue to be considered under the dispute settlement procedure in near future. So this is now issue number one, which could negatively reflect on the image and perception of the implementation of the agreement, as well as other issues. Migration is also very important because it's a very significant brain drain going on, especially not related to middle age group, but school graduates. Basically, what we as I'm working for the university, and what we can see is that significant number of Ukrainian school graduates, they're encouraged actually by our neighbor Western countries, namely Hungary, Poland, mainly these two countries, as well as Germany, by the way, to move straight away from school and to take university places in these countries under very minimum requirements. And so many very good school graduates, it's already been organized as an industry, and entrance requirements are very low. And they go and take courses and enroll, and then of course they never come back. Basically, it's they use it as a platform to stay and to work in the EU. Well, it's also a very debatable phenomenon, and again, some political parties show that the accession agreement actually leads to the, as well as Russian media, they say it leads to massive outflow of future workforce and middle class from the country. So it's some of these issues which are now on top of the agenda related to the implementation of the agreement. Just only some.
Benjamin?
Yes, I think we can take time for two last questions.
To Professor Barro and Nicolas, you described very well the duration of the length of the negotiations. Maybe how would you explain these delays in the negotiations with the southern neighborhood? And also maybe the fact that I would say not all partners in the southern neighborhood welcome this negotiation with the same appetite, I would say. And maybe to the rest of the panel, do you think the climate of the negotiations was the same during the DCFTA negotiation with the eastern neighborhood? Do you think Georgia, Ukraine, Moldavia, and Armenia had the same level of engagement, involvement in the negotiations, despite the conditions of the Russian pressure?
Other questions or comments? Yes, you can.
So I also have a question.
Okay, last round of questions. So
I want to thank my fellow colleagues in the panel for the interesting discussions. I have questions also mostly for Nicola and Catherine regarding the southern dimension and the comparisons. Nicola, you referred to the investment part and the fact that there is nothing on investment in the DCFTA with Ukraine and the eastern neighbors. It's because they were negotiated before the Treaty of Lisbon negotiations started. And in the negotiating mandates, there was not included. So that I think there is part of the explanation there. But I wonder how it is with the southern neighbors. Is it still the ambition to have it an investment chapter as an integral part of the agreement, or will it be separate, taking into account the developments in the case law and the practice of the court? So that's a question on investment. And the other question concerns visa, which you mostly refer to, the link between visa and services, which is quite interesting because with the eastern neighbors, visa and the association agreement was on a separate track because it was a visa liberalization process with different benchmarks. So it was a completely separate process, which already started actually before the association agreements entered into force. So there is just one reference in the association agreement referring to the separate process. So can you perhaps clarify or elaborate whether there is any kind of this type of dialogue or action plan, because there were visa liberalization action plans? Is there any kind of evolution in this direction, or is it simply the Tunisian side putting this issue on the table during the negotiations and the EU being reluctant to engage in this? Or how do you see this further develop?
And if I can add one more question to Nicolas, also on that investment question, you made quite maybe a bit provocative statement about the ACMEA case, and maybe you can elaborate a little bit on that while you answer to the investment protection question. Okay, who wants to start? Okay, Nicolas.
So thank you for the question, about the one about the length of the negotiation. I'm not sure the southern neighborhood countries are in a special position there, because if you look, CETA, it began in 2009 and ended in 2017, so I think we're right in time with Tunisia. But still, I think some elements can explain the delays. The articulation with the immigration policy and the negotiations of free visas and readmission agreements might delay the trade negotiation if the negotiator think of some kind of articulation between the two, because it's a very sensitive issue. And well, the question of the compatibility of the investment court system with EU law is inevitably something that delays the negotiation with all third states, because and it's very topical for the Asian ones. They don't want to conclude an agreement if a few months later the Court of Justice says that it's not compatible and everything has to go around again. So maybe it's elements of explanation, but I'm not in the secret of the negotiation, maybe, and I'm sure there's many other things. Yes, on the reasons why the Eastern Associations Agreement doesn't contain an investment chapter. Well, the pre-Lisbon argument is it's certain, but I think the Georgian negotiations began in 2010, so it's after Lisbon came into force, and the CETA negotiations began in 2009, and the mandate was modified after the Lisbon Agreement to take into account the investment protection competence. So I don't think this is. I don't know why the Eastern agreements don't have the investment protection chapter. Besides what I try to argue, but it's not it. Regarding the chapter on investment or a particular agreement, I think there will be a separate agreement. Negotiators will take into account to Opinion 215 and its consequences. On the DG Trade internet site, for the moment, the question is not clearly decided, but I don't see why Tunisia will have a special status on this question, especially because it gives the other parts of the agreement a chance to get into force much more quickly. So, and finally, yes, on my provocative ACMEA statement. Yes, of course, I'm not trying to say that we can transpose the ACMEA reasoning in all its parts in the Eastern context. Of course, the autonomy question which is at the bottom of this ruling concerns only the EU legal order, and it's not the EU legal order. And of course, it is also grounded on mutual trust, and the legal effects of mutual trust are not the same within the EU than with a third state. Still, the main argument in ACMEA, I think, was that an external jurisdiction from the EU legal system could have the possibility to interpret EU law. So this would contradict the exclusive competence of the CGU to give definitive interpretations of EU law. As the Eastern countries agreed to align their legal order on a huge quantity of EU norms, and as also the preliminary ruling procedures that the association agreement contains has two specific characters, that is it's mandatory when the arbitral panels get confronted with a new question. They have to suspend the procedure and ask the question to the court. And the ruling decision of the court that will follow this preliminary question is obligatory for them. So there's, I think, the idea behind this that some kind of uniform interpretation of EU norms in this economic space is necessary. So I just wondered if an investor from member states bring Ukraine or Georgia or Moldova in front of an arbitral tribunal on the ground of the BIT between the member state and one of the eastern countries. This arbitral tribunal would have the competence to interpret the acquis of of EU law that came into the eastern countries, and they would not have the possibility to seize the CGEU, and its awards would could be implemented without control of the jurisdiction of the member state. So I think we can find here the main elements of the ACMEA decision. Of course, it's probably very different, but it was just a guess and can be debated, of course.
Yeah, I just
Please.
it was a question about negotiations and transparency of negotiations. I would like to say that, in my opinion, from the Ukrainian point of view, the way how agreement was negotiated and presented to the public was a complete failure on behalf of the EU. Why? For several reasons. It was a very important agreement, geopolitically and economically, and it completely lacked any discussion within not only political elite, but also business communities and wider public in Ukraine. I would like to give you some facts. For example, I, as a person who was directly dealing with this topic, got access to the text of the agreement only in spring 2013, when the agreement was somehow leaked to the web, an official text of the agreement. So there was the entire text of the agreement was kept secret, inaccessible for quite a long time. And it means that basically Ukrainian public had very limited time to analyze and study the agreement before it was due to be signed. Furthermore, I remember one event, it was in summer 2013 in Prague. I was sitting at the table. On my right side was a left side German professor, and here representative of the Czech Foreign Ministry, and there was a report about the future association agreement, and this guy accessed the text of the agreement on his computer and turned the screen away from me. So I don't see it. And I asked why. He said this a confidential document, and I just opened the leaked file and showed him. Is it this one? I said yes. It was somehow, I cannot imagine why, but it was such a public failure because it caused so many problems and troubles, which were, for example, a public campaign against the agreement before the revolution in November 2013. There were posters in the underground saying that the association agreement is about same-sex marriage, hike of prices, and lowering living standards in Ukraine. So it was agenda completely hijacked by the we know from by whom. So it's a point which must be. I hope it will not repeat in the case of in Tunisian case. And regards this absence of the investment clause in the agreement, it's a very interesting issue. I never thought about it, but my presumption could be that basically probably it was the EU in the course of negotiation considered that since the conditionality clause and policy so strong, and it makes such an emphasis on reform of the Ukrainian judiciary. So basically, maybe they thought it would be better and more efficient to avoid the investment clause entirely and press the protection of investors as a part of the conditionality policy, and to to sort of push Ukrainian or Moldovan, Georgian judiciary to the position that they couldn't actually very much hamper interest of European investors, which could be interpreted as a violation of not conditionality, but judicial, rule of law principle, let's say. It could be linked to the political leverage. So it's better to avoid this very debatable provision on the investment protection, to create this new court, which is huge investment in it. You're not sure what kind of people are going to come from the other third country side to this investment tribunal, but instead to have once there is a very strong conditionality leverage, you can always be sure that if some decisions come against the spirit of investment protection, you can say, but you have to reform and ensure rule of law, and I think no judiciary in Moldova, Ukraine and Georgia would actually directly get into trouble and compromise their credibility in this sense. So it's my presumption only.
Just a few words, thank you. First of all, there is a good website, aleka.tn. You will find questions and answers. It's the first time I see a so good website, of course supported by European funds, to explain to the civil society what is a DCFTA. Take care, because it's in French, English and Arabic, but very often English pages lead you to French pages. So you know that French is the language of the negotiations. So the texts are in French, and I have to translate them for the presentations. So it was very strange to work in French and to present something in English. Ordinarily, I have the English documents and I translate them to present in French. You know, in my area, my scientific area, which is competition law. So it was the first point I wanted to explain. Secondly, Tunisia is a very poor country. If you visit Tunisia, you can visit Tunis and some touristic towns. But 10 kilometers later, you will see poverty, real poverty. And the unemployment rate for young people is very high. So the question of visa is really important, particularly for the ICT sector, which is a very good one, with people smart and very clever. And with the visa question, you really see that the EU only wants to extend its area of influence. We don't want to share what we have with these people. Thirdly, this situation is the result, for many Tunisians, of a historic injustice related to colonialism. And DCFTA is, for a lot of people, a neo-colonialism. We need to take care of this opinion. Last, I say three, but something is coming in my mind, something more. It's about the division of the labor. For many years, Tunisians have claimed about the division of labor. And the answer for a lot of economic experts is to create an integration area between Morocco, Algeria, Tunisia. It's a question of chance of value. But there is no hope. For example, there is actual, there is not a trial, but a demand for, I don't know the word in English because I'm sorry, I'm not an international trade law specialist. But in front of WTO, there is a protest from Morocco against Tunisia about exercises book for children. So the situation is not clear, and there were some big tensions between the two countries. And some people say that if Tunisia and Morocco accept to cooperate, they could negotiate better conditions for the DCFTAs. But for the moment, the negotiation with Morocco, as Nicolas said, is suspended. And for Tunisia, the negotiation is going on, but in the advantage of the EU.
Okay, so I think we can close our seminar session of this morning. Thank you again to all our participants, and thank you for the questions and comments from the audience. We'll meet. I think it's going to explode in less than 5 minutes now, so I suggest we all go for lunch and we meet back at 2 o'clock for the afternoon session, the afternoon seminar on Brexit. Thank you.